Morning, Attorney Molstein. You with us?
Yes, yes, I am.
Alrighty. Is that
I
the
think
background I see?
it's the green thing. Can you not see me?
I cannot see you. I can hear you fine.
Okay, let's see.
I'm not actually sure what that is I'm seeing.
You know what? Maybe there are.
Oh, it's just
I've got
there we
a
go.
double thing going here. So
Alrighty.
you're getting my camera and not the. I've got two screens going. So all
Yep,
right,
looks good
now
now.
we got it. Now we
Looks
got it.
good.
Okay.
So if you'll just remain on mute and have your camera closed until the court calls your case, we'd
Okay.
appreciate it.
So I mute right here.
Perfect. You are on mute and video off. Thank you very much. All counsel are present, Your Honor.
So we'll wait until 9 o'clock to have the officer open court at 9 o'clock.
Absolutely. Thank you.
Right, it's 9 o'clock now. I will have Officer Reynoso to open court. Officer?
Good morning, everyone. The 4th District Court of Appeal, Division 1 is now in session with Honorable Justice Judith McConnell presiding. We ask that you please mute your microphone and turn off your video control camera until your case is called. The first case in this morning will be Buller versus Black IPO. Thank you.
Yes, good morning, everyone. With me on the first panel are Justices Benke and Justice Irian. After the first 3 cases, there will be a panel change, and Justice Guerrero will join Justices Benke and Irian. However, on all of the cases, keep in mind that we are very familiar with your briefs and the records, so please just highlight those issues you think are most significant. We'll start this morning with Buller versus Black IPO. Ms. Harris, did you wish to state your appearance and let us know if you wish to reserve time?
Yes, good morning, Your Honor. Kristen Harris on behalf of Plaintiff Appellant James Buller. May I please reserve 5 minutes to respond?
Yes, you may.
Thank you, Your Honor. May it please the court. A jury decided that Black IPO was not liable to Mr. Buller for the injuries he suffered on the defective plywood walkway because the trial court committed 2 errors. First, it reversed its own ruling and allowed evidence of an unrelated criminal conviction from nearly 30 years ago, which unduly prejudiced the jury against Mr. Buller. And second, it allowed evidence contradicting Black IPO's undisputed responsibility to maintain that walkway.
Can I interrupt for just a moment, counsel? Justice Benke. Can you concentrate for a moment on the prejudice that may have been caused or not caused by the prior criminal conviction?
Yes, Your Honor. So the prejudice referred to in Section 352 means evoking an emotional response that has very little to do with the issue on which the evidence is offered. So here the issues are whether Black IPO is negligent and what damages Mr. Buller suffered. A criminal conviction in 1990 was not relevant to the issues and is inherently prejudicial as a criminal conviction for sexual abuse.
What do you point to demonstrate that there was prejudice?
The fact that the jury already was told that Black IPO was responsible for the walkway and that Hensel Phelps also, there was testimony that Hensel Phelps may have had some responsibility. So you can't square the jury's verdict with the testimony in the case.
Thank you.
So under Evidence Code Section 352, the trial court needed to weigh whether there was substantial probative value versus whether there was any prejudicial effect. And since the prejudicial effect is inherent in this type of conviction, it clearly outweighed such minimal probative value. And at the motion in limine hearing, the court actually already indicated that the 1990 conviction clearly appeared excludable under Section 352, and added that my guess is that's why the defendant wanted to have would like the jurors to consider an improper reason. And the court granted Mr. Buller's motion in limine to exclude that conviction. But at trial, when it mattered, the court then ultimately allowed the testimony about Mr. Buller's 1990 conviction, noting that it didn't see the felony convictions in that report, which led defense counsel to ask the witness whether Mr. Buller was arrested in 1989 for child molestation. And this decision to allow that testimony regarding the 1990 conviction was an abuse of discretion because the court should have balanced the probative value of the conviction against its potential for prejudice. Instead, the court allowed that testimony and which caused undue prejudice inherently based on that conviction. And second, this court should decide that the trial court abused its discretion in applying Evidence Code Section 352 by improperly denying the motion in limine pertaining to Hensel Phelps' potential liability and allowing that misleading and confusing testimony about the prior defendant. Because during the pretrial proceedings in this case, the original named defendant, which was Hensel Phelps, who was the general contractor, argued in its motion for summary judgment that Black IPO had contractual obligations to make the plywood walkway safe, and included an undisputed fact that the plywood walkway where plaintiff tripped was installed by Black IPO. That led Mr. Buller to dismiss Hensel Phelps and name Black IPO as the defendant. But in an interesting series of events, the same counsel who represented Hensel Phelps in that motion for summary judgment then represented Black IPO at trial and insisted on telling the jury that Hensel Phelps was the responsible party. And under these circumstances, the court should have weighed the probative value of Hensel Phelps' alleged liability, which had to have been limited given the summary judgment brief that asserted Hensel Phelps was blameless, against the probability that allowing that information may create substantial danger of undue prejudice, misleading the jury, or confusing the issues, which was clear because defense counsel for both Hensel Phelps and the current defendant already argued that Hensel Phelps was not responsible and that Black IPO was. So therefore, the court should have excluded that testimony pursuant to Evidence Code Section 352. So there are two separate grounds upon which this court can grant Mr. Buller's appeal, and the court only needs to agree on one of these grounds, although it should ultimately include that neither of these topics should have reached the jury. Therefore, this court should find that the trial court abused its discretion by allowing the conviction to be admitted, thereby creating an intolerable risk to both the fairness of the proceedings and the reliability of the outcome, and should be reversed. If your honors don't have any further questions, I'll reserve the remaining time for rebuttal.
All right, apparently there are no further questions. We'll turn the microphone over to Ms. McIntyre.
Good morning.
Yeah, please state your opinion.
Good morning, Your Honors. May it please the court, Lon McIntyre on behalf of Respondent Black IPO. As appellant has agreed in the briefing and in oral argument today, the abuse of discretion standard of review applies here, and it is an extraordinarily difficult standard for them to meet, and one of them that they have not met at all, either in providing any kind of evidence of prejudice or really any evidence that there had been an abuse of discretion here.
Counsel, this is Justice Benke. Whatever occurred to allow this conviction to come into evidence? It's nearly 30 years old. It's so different than the issues before the court, and the nature of the case is molestation, is child molestation. Now, I asked counsel about the prejudice aspect of that. Can you comment on that? Because, frankly, just speaking for myself, it's almost out of left field unless there's something in the record that explains it.
Yes, Your Honor, I'd be happy to comment on that. Interestingly, the testimony came in because of a report prepared by plaintiff's, Mr. Bueller's expert witness, psychological witness, who indicated that he had relied on the history that he had taken regarding his mental condition. And part of that history was a mention of past criminal behavior. So that opened the door for the question to be asked. But I would say that in reality, if looking at the record and the citations that we've provided in our brief, the testimony was extraordinarily brief. There were only two questions posed to the expert witness. One being, were you aware that he had a criminal history, criminal behavior in his background? And the expert said, yes, that he was. And when asked what kind, the expert testified that he had been arrested in 1989 for child molestation, and then volunteered without a question that he had been spent 28 months in prison for receiving stolen goods. So that, in terms of any potential prejudice, that was extremely limited testimony by this expert witness that was allowed in because the plaintiffs had opened the door to that testimony.
There may be a door open. It doesn't necessarily mean that the trial court has to admit it. If there's a problem with its veracity or with the nature of it, it just seems like it's so unrelated to what's before the court, those negligence actions, So I don't know. Speaking for myself, it's the prejudice aspect of it as being shown, and the question is, it's just mentioning it. Something like that, maybe you only need to mention it once, and the jury has an idea that's different from the kind of mindset that we might have here. Anyway, I wanted to ask that question because just because it's there in a report, if it's objected to, the court can simply redact it, leave it out. So anyway, thank you.
Yes, certainly. But going further to the traditional indicia of prejudice in a case like this, even if the court has allowed the testimony in, there's no real indication that the testimony affected the outcome of the trial and was prejudicial to Mr. Buehler in this case. Certainly, it was a very brief mention during this expert's testimony. There was no reliance on that argument during closing argument. Defense counsel did not emphasize or even mention that there was this criminal conviction. The verdict was not close. It was an 11-1 verdict. And as appellant has stated on appeal, Mr. Buehler's credibility wasn't really at issue. So the question was, that the jury found was, did Black IPO control this plywood walkway, and was it negligent in how it maintained that walkway? And there was disputed, conflicting evidence on that very issue. So there's really nothing other than pure speculation that the jury was influenced in any way. I'd also point to the jury instructions, that the limiting instruction that the court gave that to inform the jury regarding this testimony, that it was for a limited purpose, and that itself also prevented any potential prejudice or showing of prejudice to Mr. Buehler.
Counsel, what kind of evidence would one point to say that it was prejudicial? What would you look for? Statements from the jurors, or, I mean, just exactly what? I mean, it's troubling. Personally speaking, troubling. I can't connect it with anything in this case, unless there is something there. But it's the prejudice aspect that is the sticking point.
I would point to a couple of things, and as I just mentioned, there was no emphasis on that testimony at all by defense counsel. None has been shown on appeal that any occurred in terms of trying to influence or sway the jury. The mere fact of a remote criminal conviction is not, it obviously carries some prejudice, but it's not inherently prejudicial to the outcome of this case that involved whether or not Black IPO was negligent, and whether the plaintiff could even establish that Black IPO had built this walkway, which was a disputed question of fact that the jury decided in favor of Black IPO. So there's no emphasis on this conviction. There was no effort to try to sway the jury or to request that they consider that in their determination. And the jury was specifically instructed to limit their consideration of that testimony. So I think there's certainly, I understand Your Honor's concern about potential prejudice, but even remote criminal convictions are admissible in evidence with respect to a witness's credibility. If they've led less than a blameless life, there are certainly case law to that effect. And here there were two other subsequent felony convictions that he had on his record. And again, none of this was emphasized by the defense at trial in an effort to persuade the jury. So I think that the court correctly permitted the evidence, and there has been no showing of prejudice which would establish that it was reasonably probable that Mr. Buehler would have prevailed at trial in his negligence action against Black IPO absent this evidence. That standard has not been met. I'd also want to just point out briefly the ruling with respect to the evidence of Hensel Phelps, the general contractor on this matter, and the reliance by appellant on a summary judgment motion and a position that was taken in that motion. There was never any adjudication of that summary judgment motion. There's the points and authorities and arguments made were not evidence and were not presented as evidence in this case. And certainly the brief mention of Hensel Phelps by the plaintiff's own construction expert, Jeff Hughes, does not support any finding that there was either an abuse of discretion or that it in any way, brief testimony about Hensel Phelps in any way prejudiced the appellant or affected the outcome of the trial. So I think otherwise, I think our briefing has covered the issues, and unless the court has any further questions, I'd be happy to cede the rest of my time.
Any further questions, Justice Benke or Justice Irion?
No, thank you.
None from me, Justice McConnell.
Thank you. Ms. Harris, you may close.
Thank you, Your Honor. Quickly, just wanted to say the evidence code section 771, which allows when a writing is used to refresh a witness's recollection to let, the defense counsel can also use that writing, but it needs to be relevant to the matter that the person is testifying on. And again, the 1990 criminal conviction, that whether it was mentioned once or 10 times, this type of conviction.
Excuse me, this is Justice McConnell. This expert apparently had trouble recalling the examination of your client and had to rely pretty heavily on the report to refresh his recollection. It's my understanding that he had to, that he indicated that he considered that in his assessment. Is that correct?
No, Your Honor, he did not say that he considered the patient's background in making the diagnosis, but it's not that he looked at this 1990. Well, did you get convicted for child molestation in 1990? Then your knee issue and your pain problems are going to be diagnosed differently. So he was not relying on that 1990 conviction to determine what was going on with Mr. Buller in 2015 with his chronic pain. So he was not relying on that.
No, but he relied on that in his assessment of the man, did he not?
Your Honor, he collected background information as part of, getting to know the patient or getting the patient's background information, but didn't rely on that information to diagnose him in 2015. And then the brief testimony about child molestation is all that's needed to cause that prejudicial effect. And again, the prejudice is that it's allowing you.
Counsel, you're saying essentially it's prejudicial per se.
Yes, Your Honor. Do
you have any case authority for that?
No, Your Honor. There is case authority saying that criminal convictions are inherently prejudicial.
I understand that, but you're essentially arguing for a per se reversal without showing of any kind of evidence of prejudice or a miscarriage of justice.
No, Your Honor. The miscarriage of justice. So the abuse of discretion weighing the Section 352 probative value versus prejudicial effect. That is something that happens prior to the testimony getting to the jury. The judge is determining whether there's a risk of an undue prejudice. So, and with a conviction from almost 30 years ago, and it's a sensitive matter, a child molestation conviction, it's inherently prejudicial. So that would be why it would have a prejudicial effect and actually successfully prejudice the jury against Mr. Buller. So in conclusion, Mr. Buller respectfully requests that this court reverse the judgment below and order a new trial to exclude the unduly prejudicial information related to Mr. Buller's criminal history and the potential liability of Hensel Phelps. Thank you, Your Honors.
All right. Any further questions, Justice Benke or Justice Irion?
No, thank you, Justice McConnell.
All right. Thank you. The matter is submitted. We'll turn next to Contreras Velasquez versus Family Health Centers. You may proceed.
Thank you. Good morning. This is Mary Lehman for Appellant Cross Respondent Family Health Centers. I'd like to reserve 2 minutes for rebuttal.
All right.
There's two parts to this appeal. The first is the collateral estoppel effect of the now final findings in Velasquez 1, and those require judgment for family health.
Why is there a collateral estoppel effect? There was no final judgment entered in on those causes of action.
Yes.
There still hasn't been a final judgment entered on those causes of action.
Okay. There is authority in the decision by this court that when a partial new trial order is entered, that the other causes of action not subject to the new trial order do not become a judgment. There is authority to the contrary that says that those, when the new trial order disposes of causes of action versus just damages, that those remaining causes of action do indeed become reviewable. And we discussed those cases in our brief. There is authority also that although something is not final for appealability purposes, the findings of facts still are subject to collateral estoppel, and that's the Reedy and the Burgermeister case. Bottom line is that we have inconsistent verdicts, and if the verdict in Velasquez 1 did not come up for review in the appeal from Velasquez 1, the law states that they are up for review now. So you have an inconsistent judgment, inconsistent verdicts, and under the inconsistent verdict law, it requires a new trial. One of the main purposes of collateral estoppel is to prevent the inherent contradiction and unfairness of a party being subject to inconsistent verdicts. And that's what we have here. In the first action, Family Health Centers was completely exonerated. Then in the second trial, on limited causes of action, but with the same issues, it was hit with an almost $7 million verdict. Collateral estoppel is meant to prevent this contradiction and injustice. But if
you don't give any weight to the fact that the trial court granted a motion for new trial.
The trial court granted the motion for a new trial on 3 causes of action only. And this court affirmed that new trial motion, but in reviewing that order granting new trial, it deferred to the trial court and reviewed it for abuse of discretion. This court did not review the verdict on the causes of action that were not subject to the new trial motion. The law of the case does not apply. This court did not decide that those non-reviewed causes of action were not supported by substantial evidence.
I want to address the issue of punitive damages.
Thank you. If the judgment is not vacated due to collateral estoppel or a new trial granted for inconsistent verdict, at a minimum, punitive damages should be reduced to a 1-to-1 ratio. Family Health Center's conduct here did not demonstrate indifference or reckless disregard for the health and safety of others, including Velasquez. Its bad conduct was essentially stating she had resigned versus being fired and not trying hard enough to find her a new position or for finding a left-handed working mouse quickly enough. This is not what we would normally term a case of intentional malice, fraud, or deceit, trickery.
May I ask you a question about what the trial court found here? Did the trial court actually find that Family Health's conduct showed a conscious disregard of the health, safety, and rights of the plaintiff?
No. I think
Didn't they make that finding? Didn't the trial judge make that finding?
Conscious disregard
Of the health, safety, and rights of the plaintiff.
The trial court found it mostly demonstrated indifference to her economic interests, and it was more neglect than malice. The trial court specifically found more neglect.
Anything further?
Sure. It's undisputed that Family Health Center's actions were indeed to support her physically and to prevent her from further physical harm. It's undisputed that Family Health Centers gave her light duty jobs when she had her surgery. It retrained her, gave her a 4-month leave of absence when doctor's reports said she could not work ostensibly with either hand, their disability was permanent, and the report said she wanted to be taken off work permanently. And then we let her go. So this was not a case, for example, where there's asbestos causing and cancer causing elements that the defendant is not telling people about. This is not that case. Where reprehensibility is low, which the trial court found here, the ratio of compensatory to punitives should be a 1-to-1 ratio. And that's the United States Supreme Court and the California Supreme Court. Cases higher than a 1-to-1 ratio must show an extreme degree of reprehensibility or utterly indefensible conduct. This is not that case. This was like there was no evidence that family health centers had done this before. There were complaints, but there was no evidence that those complaints were valid. Family health centers employs 2,000 people. As the trial court found, this was more neglect, and that's a quote, more neglect than malice.
I think you need to check the record on that, because I do think that the trial court found otherwise.
Okay, more neglect than malice. I'll give you the page number.
No, the finding that the family health acted in conscious disregard for the plaintiff's health, safety, and rights.
It's health and safety of others, right? I think the distinction perhaps of what the trial court was talking about is the health and safety of and rights of Velasquez versus not just itself. So it did disregard the rights of others, but that doesn't rise to the level of the cancer-causing materials, and it was more neglect than malice. And I will find that cite for this court on my rebuttal. Okay. A key point that the trial court did find is that the compensatory damages here were high, $1 million approximately, and 3/4 of that, more than 3/4, $750,000, was emotional distress damages. And the trial court found that those contained a punitive element. And the law is when compensatory damages are high, and especially when those compensatory damages contain a punitive element, which this trial court did find, that a 1-to-1 ratio is usually the outer limits of constitutionality. With that, if there's no further questions, I'll save time for rebuttal.
All right, thank you. Mr. Buchanan?
Yes, good morning, Your Honors. May it please the court. Martin Buchanan appearing for Rosario Contreras Velasquez. Just briefly on the collateral estoppel issue. First, I want to respond to something that came up for the first time in their reply brief. In their opening brief, the only issue they raised was collateral estoppel. In their reply brief, suddenly there's a whole new argument heading that says, alternatively, the inconsistent verdict requires a new trial, and goes on for pages about the allegedly inconsistent verdicts, separate and apart from collateral estoppel. I just want to note for the record, we do object to them raising that inconsistent verdicts issue for the first time in their reply brief. We have not had an opportunity to address it. We would have had a response to it. We would have actually asked for the court to take judicial notice of the record in the first trial and compare the evidence in the two trials. So we object to that being raised for the first time in the reply brief. Notably, it was also raised for the first time in the reply brief in the first appeal, the same issue. So that's been forfeited. On the merits of the collateral estoppel issue, just very briefly, we've given multiple reasons why that issue has no merit. But Justice McConnell is correct. There was no final judgment to give preclusive effect to, because as a matter of law, Judge Lewis's order granting a partial new trial vacated the original judgment, and that the judgment on those other causes of action was still subject to a potential appeal after the final judgment was entered on retrial. So for that reason, collateral estoppel doesn't apply. Unless there are questions about that issue, I'd like to devote most of my time to the punitive damages question.
Are there any questions on that point, Justice Banky or Justice Irian?
No, thank you.
No, and I think, Mr. Buchanan, on this issue of punitive damages, The trial court heard all the evidence and made specific findings with regard to reprehensibility, finding, I think, a moderate degree of reprehensibility. And the point that Ms. Lehman made about the amount of non-economic damages is something I think the trial court considered in the overall weighing of how much the punitive damage should be. So for me, that's something I think you ought to discuss.
Yes, Your Honor. So first of all, I do agree, Justice McConnell, the trial court made an explicit finding that there was conscious disregard of the health, safety, and rights of the plaintiff. That's at page 2089 of the clerk's transcript. Ms. Lehman said the trial court found a low degree of reprehensibility. That's not correct, Your Honor. You are correct. The trial court found a moderate degree of reprehensibility, but it did so in part based on its legal error in finding that the conscious disregard reprehensibility factor required conscious disregard of the health or safety of people other than the plaintiff. I think we've demonstrated through our citations to Roby and Colucci that that's not correct. And again, this court engages in de novo review on this issue, so it need not give any deference to the trial court's factual findings or its ultimate determination on reprehensibility. And we've gone through the reprehensibility factors, so I don't want to do that again, but let me just focus on the few facts that I think highlight why the reprehensibility here should be found to be on the moderate, late, high, or high end of the scale. First of all, let's not forget what this case is all about. What this case is all about is that Ms. Contreras-Velasquez had a physical disability with her right arm. All she needed to perform her job in the call center was a functioning left-handed computer mouse. That would have been, what, maybe $25. So for whatever reason, it still hasn't been explained to this day. Family Health Centers, which has a net worth of $213 million, didn't want to spend the $20 to give her a functioning left-handed computer mouse to accommodate her physical disability. Number two, this conduct was not just committed by some low-level employee or even a mid-level manager. This misconduct went all the way to the very top of Family Health Center's corporate headquarters. The decision to terminate Ms. Velasquez was made by the HR manager and HR director, the two people at the very top of the HR department in corporate headquarters. In addition, Ms. Velasquez was very persistent about articulating her rights and showed up at the Human Resources headquarters protesting the decision, and then actually wrote a letter to the CEO complaining that, in essence, she was being discriminated against based on her physical disability, was not being accommodated. She disagreed with the false characterization of her termination as a voluntary resignation, which incidentally, that decision to so characterize it was made by the HR manager in the HR department. And yet the CEO, in response to this letter, did absolutely nothing. Here she has a letter where somebody is complaining about failure to accommodate a physically disabled person, about false documentation of the reasons for the termination, and she does nothing, apparently, other than file away this letter in the personnel file. So one thing that makes this case different from cases like Roby and Colucci and the cases that FHC has cited is the involvement of people at the very top of the HR department of a large organization. These are the people who are charged with implementing the state's employment laws. These are the people who should know about accommodating a physically disabled employee, about engaging in the interactive process. It's not some isolated mistake by a low-level employee or a mid-level manager. So that's why a particularly high level of punitive damages is necessary to deter and punishment. The higher up in the corporate hierarchy the misconduct is, the greater the punitive damages should be to deter and punish. The other point I want to make about reprehensibility is, I think of all the cases, including, again, Roby and Colucci, there's no case that has the level of financial vulnerability that my client had in this case. She's a 55-year-old woman. with a physical disability, a high school degree from Mexico. She depended on her $13 an hour job for her living expenses. She was unable to get another job for 3.5 years. She became homeless at one point. She used up all of her savings, and she could no longer afford to purchase a car. She had to borrow money from friends. She was still in debt at the time of the retrial. And she suffered very serious anxiety, depression, PTSD, suicidal thoughts, and that was ongoing up until the point of trial. So Justice McConnell, to now get to your question about the level of the compensatory damages. I think one thing that's unique about a case when somebody who's a very low wage earner is terminated is the economic damages are going to be low because the wages are low. But at the same time, the non-economic damages are going to be quite high because this is somebody who's already living on the edge, making $13 an hour. And so when you fire someone like that and they're immediately plunged into this kind of financial insecurity where you don't know how you're going to pay your next bill, the non-economic damages are naturally going to be higher. It's not like some executive was fired here who has savings to fall back on, who has a 401k, who might have family to help out. This woman was all on her own and she had nothing. She literally showed up at HR after she was terminated, begging for her job back, telling them there are many jobs that I can do at family health centers. In fact, there were over 100 jobs that were open at the time. Not only could they have accommodated her by giving her the roller mouse for $20, they had other jobs they could have given her. That's what the evidence shows. There were multiple ways they could have accommodated her. So in addition, I would note that this court in Gober versus Ralphs, that was a case where the court also found, well, first of all, it found that there was only a modest degree of reprehensibility, and it also found that the compensatory damages already included a punitive element, as the trial court here found. And yet the court said that 6-to-1 was the maximum constitutionally permissible ratio. Now, Gober was not cited or discussed in this court's decision in Colucci. Colucci is factually different, but Gober is a case where, the 6-to-1 ratio, I think, is instructive in this case, and the jury's original award here is less than 6-to-1. It's also significantly less than what the California Supreme Court in Simon said was a ratio that raised a presumption of unconstitutionality, that being 9 or 10-to-1. So essentially, a single-digit ratio, as the jury here awarded, 5.6-to-1, doesn't raise any presumption of unconstitutionality. So there's nothing here that would give rise to such a presumption. The other thing I want to go back to about the amount of the compensatory damages that just doesn't really make sense to me. Let's assume that it's correct that the compensatory damages contain a punitive element, and we don't concede that as we've argued in our brief, but let's just assume it's correct. Well, the compensatory damages were $750,000. Let's say the court concludes that, I don't know, half of that is a punitive element, so $375,000. How would that be a ground for reducing the punitive damages by $3 million, as the trial court did? I mean, if these awards are duplicative, then the court should strike the duplicative amount and not reduce the punitive damages by many more times than the entire sum of the compensatory damages. That just doesn't make sense. And it was for the jury in the first instance to decide what was necessary to deter and punish family health centers. And one of the things the law and the jury instructions certainly allows the jury to consider is the defendant's financial condition. So here we have, for a nonprofit, it's just an extraordinarily positive financial condition. And I've been on nonprofit boards. I've never seen anything like this. Their net worth was $213 million. They had $95 million cash on hand, which included a $44 million rainy day fund that wasn't earmarked for anything. So when you consider the defendant's financial condition, on top of the fact that this misconduct was committed by people in the very top of the corporation, at the very top of the HR department, the jury was entitled to decide, we need to send a message here, and the award of punitive damages has to be something that isn't just treated as a routine cost of doing business or a nuisance by family health centers. It has to be something that the people at the very top of the corporation.
Are you saying that 1.83 million is just a nuisance to this company?
It's something like 3 days operating expenses, Justice McConnell. Their operating expenses were $500,000 a day. So, I mean, obviously 1.8 million in just non-relative terms sounds like a lot, but it's not a lot in comparison to their daily operating expenses, in comparison to their net worth, in comparison to their $44 million rainy day fund. And again, the court's task here, again, this is how the court ended its opinion in Gober. The court's task is not to determine the amount that the court believes the jury should have awarded. It's not to determine what this court would have awarded if it had been the fact finder. It's to it's to find the maximum constitutionally permissible damages as a matter of due process, allowing leeway for reasonable differences of opinion. And I think we have to respect the jury's decision, especially given that it does not, it's well below the double-digit range, within the range that's not constitutionally impermissible. And the jury had ample reason to, based on the net worth, the financial vulnerability of my client, and the extent to which this misconduct reached the higher upper end of the corporation, those were all valid reasons for the jury to decide a high number was necessary to really send a message and make sure that in the future, this corporation knows something about how to engage in the interactive process. They had no policies on engaging in the interactive process. There's no evidence that anybody was properly trained on how to engage in the interactive process. And the facts of this case just practically scream the need for a message to make sure that this corporation, this nonprofit corporation, does not engage in this kind of conduct in the future, does not just get a letter, the CEO getting a letter from somebody alleging this kind of misconduct and file it away without asking anybody to investigate it, without asking anybody to look into it, without responding to the letter writer. I mean, that's just a level of arrogance that the jury was entitled to decide required a strong message and strong medicine. So,
all right, Mr. Buchanan, you have used up your 15 minutes. Are there any further questions of Mr. Buchanan, Justice Benke, or Justice Irion?
No questions.
All right, thank you. Ms. Lehman, you may close.
Thank you. Just quickly, in our reply brief for the inconsistent verdict argument, that was in response to cross-respondents' arguments that the new trial order was partial and did not bring up the judgment until the judgment in this action. So it's either, if it's not collateral estoppel, then it's inconsistent verdict. So it was in response to their argument. Addressing this court's question regarding the trial court's finding on reprehensibility, on the top of page 2989, the court said it was more neglect than malice, and the court found it's not extremely reprehensible.
But the court stated overall the evidence shows a moderate degree of reprehensibility after having stated the evidence, including these and other facts, which was talking about the fact that they said that she resigned instead of being terminated. It was a conscious disregard of the health, safety, and rights of plaintiff. We have the record in front of us. We don't need to quibble over it, but that's what I see in the record.
Okay,
so we might want to move on to some other points.
Okay, well, I would just say it's not extremely reprehensible. The court found that, and the court did find neglect versus malice. So I guess we're on a continuum, and I'm finding on the continuum that it's less reprehensible than many cases. We're not saying punitive damages should not be awarded. All we're saying is that the 1-to-1 ratio, according to case law and the facts of this case, is the correct standard. If this court compares the conducts in Robbie, for example, where the supervisor was intentionally belittling and mocking and harassing a person with disability. That is not this case. The conduct of saying that she had resigned versus being let go, that there was evidence in the record that this was done to protect her, to let her help her get another job.
And she couldn't get benefits.
But she was getting disability, and you can't get disability in unemployment. And she admitted in the record that she was getting disability, and everybody knew that she was going to get disability because she was disabled because she couldn't work. And it's my experience that most of the times employers do allow you to resign for that reason. As far as reprehensibility of our conduct, there was the doctor's reports did not specify whether she had whether her disability was in just her right hand. At points it said it was also in the left. The doctor conceded it was ambiguous. In her own report to the doctor, Velasquez says that she did have pain on both sides. Her doctor's report said that she did not want to continue working.
Didn't the doctor say to the employer, "I'm happy to talk further with you"? And nobody ever called the doctor?
We called the nurse in charge of her case. Family Health Centers did not talk to the doctor, but we did talk to the nurse, and that's on the record. The evidence is that we did have interactive process policies. They weren't called that, but that's what the testimony said. And there was evidence that we did try to help, that we said we have these job opportunities. We could have done more, but it's not that we ignored her. The fact that Velasquez sent a letter to the CEO of this large corporation does not necessarily mean our CEO was, filled with malice or reckless disregard. You can't, as a CEO of a large nonprofit, the largest healthcare nonprofit in San Diego, you can't respond to everything. It was addressed. We did follow her up. We did on this record. Again, we're not saying we didn't do the wrong things. There's no evidence that we had done this before. We tried to do it right. There's contradictory evidence that everything we did had a reason. Yes, Velasquez is economically vulnerable, as all blue-collar workers are. Most people do live paycheck to paycheck. In reality, she had more. She did have savings. She had investment property. She lived in a nice location, and she did have a car. And that is more than many blue-collar workers have. And you can't say that every non-executive is financially vulnerable. We agree that she has some degree of vulnerability economically. But we knew that workers' compensation would cover her. And another aspect is that the case law says here she was awarded her attorney's fees. And when a plaintiff in these cases is awarded attorney's fees, the court needs to consider that her compensatory damages, her compensatory recovery will be more because she doesn't have to pay her attorneys out of that recovery. As far as defendants' I'm sorry if you keep hearing that pop up. As far as defendants' financial condition, it's well established that the punitive damages should not destroy a company, that you have to consider the effect on the company. Here, Family Health Centers is the largest nonprofit healthcare provider in San Diego that provides important life-saving care to the most vulnerable in our community, regardless of their inability to pay. The quote-unquote slush fund that council said that we have is twofold. It was explained in the balance sheet that was necessary because at any moment the Affordable Care Act could be changed, and so we would have to cover those expenses, and that money was already committed, which we have to do through grants and such to provide health care and other support programs for the elderly, homeless, minorities here. and San Diego. So that should be considered when we talk about the defendant's financial condition. Again, under case law, compare the facts of this case with the other cases and the guidelines in Robbie and Simon and Walker. 1-to-1 ratio is the constitutional maximum. Unless there are any questions, I'll submit.
Justice Banky or Justice Irion, do you have any questions?
No, thank you.
All right, thank you very much. The matter is submitted. All right, we'll now take the matter of Reyes versus Lightborn. Mr. Wolfinger, could you state your appearance and let us know if you would like to reserve time to respond? I can't hear you. You're on mute, Mr. Wolfinger. No, you're still on mute.
Okay, wait a second.
There, now we can hear
There
you.
you go.
We can hear you. All right, just state your appearance, please, and let us know if you'd like time to respond.
Charles Wolfinger for the appellant. I'd like a few minutes to respond.
All right, thank you. You may proceed.
Well, you know, after writing a 67-page appellant's opening brief, I think I've sort of said it all, but I just want to emphasize a couple of things. There is virtually no indicia that the Superior Court looked at the evidence. There's nothing, especially the ruling that said, you know, I'm just going to adopt the decision of the administrative agency. And as you know, we did request a statement of decision, and specifically on the issues in the head notes to the appellant's opening brief. We didn't get it. There's virtually no attempt to argue or rebut our claims that the two basic eligibility conditions for needing protective supervision are incorrect. They just ignore it, as if I never addressed it. And finally, this is probably, I've done hundreds of these cases involving protective supervision. It is the most controversial service in the IHSS program. The state has issued no regulations clarifying anything. The one all-county letter, 1525, where they said you also have to be non-self-directing and point to the two decisions in Marshall and Calderon, I think are completely bogus. I mean, I don't know why it took them 22 and 29 years to figure that out, or why they haven't issued a regulation in 5 years after they said they would when they issued that all-county letter. But what's silly about it is the trial court says he's self-directed because he chose to go off his ADHD medication. Well, what that does is it makes him a little crazier and nuttier and engage in dangerous behavior. So I think it's just it's virtually it's undisputed that he needs it. And the one final thing is the one case, my most famous appellate decision, which took 20 years to finally implement, and yet the attorney's fees, was Miller. And Miller was about a regulation that said, if you live with someone, an adult, we're not going to give you protective supervision because they're going to provide it to you anyway. And that's exactly what they assumed here. There was no indication that his behavior was affected by his mother's presence. The regulation does not say you have to intervene 24 hours a day. It says you have to observe 24 hours a day and intervene as necessary, which his mother did.
Justice Binke, I'm just switching gears maybe up a little bit here. What were the primary dangers to Seth? What were the primary dangers? I see the broken bones, and I can see the being taken advantage of by others. Is there anything else
Well, if he left the house, he wouldn't know, how to negotiate traffic or anything. I mean, that's why the mother put the alarm on the door. Of course, the alarm on the door means nothing if there's nobody at home to hear the alarm. So he could just walk out of the house and into this world that most of us can negotiate, but he can't.
Okay, thank you.
Anything further, Mr. Wolfinger?
No, Your Honor.
All right, we'll allow Ms. Trin to respond. Ms. Trin?
Good morning, Your Honors. May it please the Court, Deputy Attorney Julie Trin, on behalf of Kim Johnson, the Director of the Department of Social Services. Your Honor, I won't resuscitate my brief for you. I'll just briefly address some of the points that has been raised by Mr. Wolfinger. The first point that he made was in regards to the statement of issue. While appellant did bury a request for a statement of issue in their opening brief, what the request was made was not a proper request for a statement decision under CCP 632. In order to request a proper statement of decision, appellant needed to do two things. One, he needed to have made the request after the tentative ruling was announced, within 10 days after the tentative ruling was announced. Two, if appellant felt that there was an omission of the statement of issue, there were remedies available to appellant under Code of Civil Procedure Section 634. Appellant did not request a statement of issue after the tentative ruling was issued, and he did not take advantage of any of the remedies required under CCP 634. So there was no valid request for a statement of issue. Therefore, the trial court did not have to make any specific findings or rulings. And in that particular case, then what is before this court is really a question of whether or not there is substantial evidence to support the trial court's ruling, and that any evidentiary contradictions or conflicts or inferences must be presumed in favor of the judgment and in favor of the trial court's determination that appellant was self-directing and did not need 24-hour supervision. Secondly, in regards to the issue of self-direction and regulations, the administration of protective supervision is well grounded in existing statute, regulation, and case law. In fact, under Welfare and Institutions Code Section 1230 Subdivision E, the statute states that protective supervision is provided as needed to individuals who are unable to provide that service for themselves and cannot remain safely at home without this service. The department's regulation then further defines protective supervision as being consisting of observing the recipient's behavior and intervening as appropriate to safeguard the recipient from injury, hazard, and accident. Two appellate courts have then further clarified protective supervision under Marshall versus McMahon, as well as Calderon versus Anderson. And those appellate courts have stated that since protective supervision consists of observation of the recipient's behavior, an individual who is self-directed, therefore can observe his own behavior, does not need protective supervision. But taking that all aside, even if this court were to find that non-self-direction was not an eligibility requirement, there's still a completely separate eligibility requirement that has not been met in this particular case and therefore precludes appellant from protective supervision. And that's the requirement that there be a need for 24-hour supervision. Appellant doesn't dispute that this is a requirement. What appellant is disputing is the factual findings made by the trial court. And in this particular case, under a substantial evidence review, the factual findings must be presumed in favor of the trial court's decision. So although the appellant may not like the trial court's decision, if there is substantial evidence to support that decision, then this court must affirm. And in this particular case, there is substantial evidence of that appellant was self-directing, as well as that he did not need 24-hour supervision. In regards to the self-direction, we have an individual who was in a general education program for a majority of his time at school. He chose to graduate and enter into a vocational program over his mother's objections. He also recognized his condition in regards to the medication he was taking and made the conscious choice to discontinue the medication because he felt that it made him less interactive. Again, he made that choice over his mother's objections. There's also evidence that appellant has indicated a desire to move out of his home, rent his own apartment. And again, he recognized that he needed, in order to rent an apartment, that he needed to get a job, build up his credit, and save up. There's also evidence in the record that appellant is able to safely use his phone, safely play on games online, and safely make purchases for himself as well as others. So there's more than substantial evidence in the record that appellant was self-directing. Now, in regards to the 24-hour supervision, I'm going to disagree with appellant's counsel in that he's not under the supervision of his mother 24/7. In fact, the record reflects that at minimum, 35 of the hours a week was spent in a school setting. And there is no evidence in the record that while he is away from his mother, that he engaged in any self-endangering behavior. In fact, the record is clear that appellant was not only able to safely navigate the educational system without one-to-one care, but that he is also able to engage in social interactions, in particular with a girlfriend who he engaged in sexual relations outside the presence of his mother, outside the presence of the school. There's also evidence in the record that appellant is able to take walks to the grocery store. He's able to be left alone without his mother being present, with no self-endangering behavior, and that his mother was able to leave him alone by himself for a short period of time. So, Your Honor, there is just no evidence in the record that appellant currently engages in self-endangering behavior such that he needs 24-hour supervision. And just to quickly address appellant's argument in regards to the Miller case, the Miller case is not relevant to this case. The Miller case involved a roommate exception, which is not applicable to this case. We're not saying that the fact that he lives with his mother is a exemption of protective supervision. What we're saying is that the record does not reflect that appellant required 24-hour supervision. The trial court correctly exercised its independent judgment, reviewed the complete record, and applied the correct legal standards. Therefore, the department respectfully requests that this court affirm the trial court's judgment in favor of the department. Barring any further questions from the court, the department will rest.
Any questions, Justice Benke or Justice Irian?
No, thank you.
All right, thank you. Mr. Wolfinger, you may close.
I've known Ms. Trin for decades. We've gone around in these cases over and over again. I would just say that when he was at school, he was supervised by 2 teachers. He had a special ed teacher, had a special ed program. Of course, he was in a regular classroom, but 90% of the time, he had 2 people, 2 adults watching what he did. Miller is relevant because the regulation said if you have an adult housemate, you're getting protective supervision, so we're not going to pay for it anyway. And the court ruled no, you have to pay for it. These cases are difficult because if his mother had loosened the reins, and actually the record shows that she follows him to the grocery store in her car, or she leaves and she stands on the front porch and then comes back in to give him some sense that he's independent. But if you look at the facts, you can't say that this person could live safely at home without an adult present.
All right, anything further, Mr. Wolfinger?
No, Your Honor.
Any questions, Justice Benke or Justice Irian?
No, thank you.
All right, thank you. The matter is submitted, and now I'm turning the gavel over to Justice Banky, who will preside, and Justice Guerrero will join the panel. Thank you.
Okay, thank you, Justice McConnell. We are going to be hearing Wilson versus the La Jolla Group, please. Are counsel ready to proceed?
Yes, Your Honor.
Okay, very good. Let's hear from the appellant then.
Thank you, Your Honors, and may it please the court, Alexander Wheeler on behalf of the appellants. I'd like to start, Your Honors, with the reasons why the trial court's order should be reversed, given that we have extensive briefing on this case. The standard of review, Your Honors, is limited to the review of the trial court's stated reasons for denial of class certification and whether or not those stated specific reasons that the trial court has made in its order are correct. In the trial court's order, which is what we naturally go to when that's the standard of review, there is no analysis of the plaintiff's theory of recovery. And the Brinker case, the California Supreme Court case in Brinker, tells us that the trial court must undertake an analysis of the plaintiff's theory of recovery. There is also no analysis in the trial court's order of the plaintiff's causes of action individually. And the Second District Court of Appeals recent case in Gonzalez instructs that that is error as well. Gonzalez tells us that when a trial court looks at a complaint holistically in its totality and fails to analyze the individual causes of action that are subject or not to certification, that's error. And that's why the court in Gonzalez sent the issue back to the trial court with directions to consider all of the causes of action. And let me just play out for the justices exactly why that matters and why it compels reversal in this case. The plaintiff's theory of recovery here is that the potential or putative class members were all improperly classified as independent contractors as opposed to employees. Now, the rubric for that test used to be pre-2018 was, as I'm sure the justices are aware, the S.G. Borrello and Sons multifactorial test. Right of control was the paramount consideration, but there were 8 factors that courts would consider in determining proper classification. Now,
Mr. Wheeler, this is Justice Guerrero. Before you get into some of the details regarding the applicable standard, Borrello versus the Dynamex, I wanted to clarify your position. You seem to focus a significant amount in the briefing on the misclassification issue, which you touched upon a little bit now. Do you concede that that's not sufficient? Misclassification alone isn't sufficient to obtain certification, that you instead have to determine, or would need to determine, that that issue predominates? And how do we find that here, given the wide variety of circumstances in terms of the work experiences of the class members?
To briefly answer the court's question, yes, I concede that predominance is what the court considers. Absolutely. Predominance of common issues is what must be shown for a class action to be certified. So yes, Justice Guerrero, I do concede on predominance. And here's why we can prove it here. And that's why I was getting into, Your Honor, the sea change in 2018, not only as far as the law, but as far as how independent contractor versus employee status is proven and tried in this state. The Dynamex case in 2018 did away with the multifactorial test, which makes it much easier to show predominance of common issues. Now, there's not a lot of Court of Appeal case law following Dynamex, which is why I direct Your Honors to the Gonzalez case, because all the cases that the respondent relies upon are pre-Dynamex. Now, that matters because there's no longer a multifactorial test. For example, in the Sotelo case and in the McCleary cases, which the defense relies upon heavily, those are pre-Dynamex. They are Borrello factor cases. Now, what what Dynamics does is says that the issue, by the way, which is the defense's burden to prove, proper classification, not the plaintiff's, but the issue before the court is whether or not one of the three prongs can be proven by the defense. So there's no longer an 8-factor test, there's a 1-factor test. And if the defense doesn't prove any of them, then the issue is decided in favor of the employees. And that's, is the work performed by the class members, the putative class members, outside or inside the usual course of business that the defendant exists to perform? That's it. That's the only issue we moved upon. That's in other words, Your Honors, our theory of recovery that the trial court failed to consider. Now, Justice Guerrero, you mentioned the trial court did talk about some variability of the experiences of the class members in its order. Now, when you look at the trial court's order, the hearing transcript, the tentative ruling, there was zero analysis of any of these legal issues. The only, in fact, literally the only reasoning, and I remind the justices, this court is limited to reviewing the trial court's stated reasons, and here they are. Quote, you've got people that work all over the state, different counties, different wage rates, no time records that I'm aware of, 5 years, everybody's got a different story, end quote. None of those, Your Honors, are reasons to deny certification, not a single one of them. Class actions throughout the state involve people that work all over the state. The first trial court's first reason. Different counties. Well, the fact that different employees work in different counties does not preclude any finding of predominance. Different wage rates, that's a damages issue, which it's black letter certification law, Your Honor, that different wage rates is a damages question, not a liability question. And the fact that there's no time records has no bearing on whether or not the plaintiff can prove predominance of common issues on either liability or damages. And that's very clear in the Hernandez and Mount Clemens cases that are in our briefs. There's never time records, Your Honors, in an independent contractor misclassification case. The defense has admitted there are no time records, no wage and hour policies at all. And before Your Honor asked that question, what I was going to get into is, let me show you why this matters, why this has to go back to the trial court with instructions. 226 wage statement penalties are automatic. So if the plaintiffs are correct that these employees were misclassified as independent contractors under prong B of Dynamics, California Supreme Court 2018, if we're correct on that, and this is something that respondents never mention, it's never in any brief, that the trial court didn't consider it, of course, either. But if we're correct on that classification question, wage order 226 penalties flow automatically from that misclassification. There is no variability in that question at all. So the same is true for the meal breaks. Under the Bradley case, if there is no policy to provide meal and rest periods, it is not grounds to deny certification that some people may have inadvertently taken them, because the California law question is, did the employer provide them? In this case, there were requests for admissions where the defendant admitted there were zero wage and hour protections in place. Now, because of that, there are wage statement and other labor code violations that flow automatically therefrom. Another response to Justice Guerrero's question is, there is no dispute about the core job duties at issue in this case. Sure, I concede and I recognize that the defense put in evidence that the class members are, quote, free spirits. They work when they want and a lot of the times where they want. That is irrelevant to the Dynamics prong B analysis, Your Honors. Completely irrelevant. Because there was no dispute about the job duties, the core job duties. Job locations, how and when they worked, there's some variability there. But what they did, the kind of work they did in their core job duties, absolutely undisputed. And that's in the record, Your Honor. There's a special interrogatory and some deposition testimony before Your Honors that say that these signature gatherers did the same task over and over again. Where and how they did it may have differed, but that under the usual course of business test, the prong B test is completely irrelevant.
Does it matter at all that the signature gatherers could obtain blank whatever documentation from one entity and then return it to a separate entity? Does that affect your analysis at all?
Thank you, Your Honor. No, not under the prong B analysis. Does what the signature gatherers did as their core job duties, does that fall inside or outside the company's usual course of business? The fact that they can gather forms and give them and be paid by another company has no bearing on whether or not the actual job duties they did, which are undisputed, satisfy that prong. So the fact that they could pick up the forms and turn them in elsewhere, I don't think it's has any bearing whatsoever on the independent contractor status. Perhaps under Borello, I don't think it would be even relevant there. But I could see the argument that under the Borello standard, which, if you look at the Gonzalez case, doesn't apply to any of the claims in this case. In a multifactorial test, perhaps. In a unitary test, which is what the California Supreme Court has given us today under dynamics, it has no bearing whatsoever, Your Honor.
Okay, Counsel, you have 5 minutes remaining. You can use it now or you can save any part of it.
Justice Benke, thank you so much for that reminder. I forgot to set aside some time. I would like to set aside some time to respond to my opponent's arguments. So let me do that now, Your Honor, and I will address Your Honors when I close it. Thank you.
Okay, if we can hear from respondent.
Good morning. May it please the court, Liddell Muhlstein representing the La Jolla Group and Bobby Glauser. As the court is aware, the trial court denied class certification on 2 grounds, 2 reasons. First, the plaintiffs failed to establish that the class action is a superior method of adjudication. And second, the plaintiffs failed to establish that common issues predominate. And the ruling can be affirmed on either ground. And I would like to point out that the court, when counsel said we want reasons for your Honor's ruling, the court directed the parties to submit a joint order that they both approved of, and that order has the reasons, the 2 reasons that the court found, and also repeats the comment that the court made in the course of the argument about some of these reasons. But I think the main reason is everybody's got a different story, and that comment, that analysis applies to both to the predominance issue, but also to the superiority issue. So I'd like to talk about superiority first.
Counsel, before you move on to that, I wanted to also clarify that point about the sufficiency of the stated reasons. The court did articulate the correct legal standard in citing common issues and superiority. Is that correct?
Yes.
And what level of detail do you recall was in the proposed order by appellants when they submitted their proposed order granting class certification?
Well, the proposed order basically talked about what are the issues. It did not discuss, and it said these are the grounds, these are the reasons, and then it included the quote that counsel just gave you that was made during the course of, offhand by the judge during the course of.
I guess what I'm getting at is, did the court's ruling have comparable detail to the initial proposed order that was submitted with the moving papers? Do you recall?
I do not. I do not remember what the initial. I'm sorry. I have not reviewed the initial proposed order. I did look at the joint proposed order that the court signed.
Okay. Thank you.
After the parties were directed to come up with an order that they both agreed upon in terms of reasoning, and this was what was submitted and this was what was signed. With respect to superiority, even when common questions predominate, so even assuming that the appellant could have shown that, certification should be denied when litigation of individual issues as to liability and as to damages cannot be fairly and efficiently managed. And I quote from Duran from the Supreme Court, "The manageability of individual issues is just as important as the existence of common questions." And as the courts have noted, this case presents overwhelming case management challenges. The plaintiffs failed to present a manageable or any trial plan. The case involves some of the most varying work conditions imaginable. The hours worked by the individual gatherers varied from day to day, month to month, year to year. They depended on a host of factors, including the election cycle and personal preference. They did not work every day. Their schedules were erratic and unpredictable and varied widely. Not one of the 12 declarants worked a set schedule. One gatherer based how often and how long she works on such things as how many petitions are available, the time of year, my kids' schedules, other jobs, family obligations, vacations or trips, how I'm feeling health-wise, whether I need extra money, etc. As the trial court observed, everybody's got a different story. Given the wide divergence of the work practices among the signature gatherers, there is no dependable method other than individualized testimony by which the hours worked daily by the individual gatherers can be shown, which is necessary to establish liability for the plaintiff's claims. Simply proving prong B misclassification is not sufficient. The plaintiff is required to show, for example, if you take overtime, misclassification does not entitle you to overtime pay unless you worked overtime hours. And the plaintiff has the obligation to prove overtime work and has to do that by common proof. But it is impossible to do that by common proof in this case, given the variability, the extreme variability among the experience of the different workers. Because trial courts are ideally situated to evaluate the efficiencies and the practicalities of permitting group action, they are afforded great discretion in granting or denying certification. So this court looked at the fact that everybody's got a different story and determined that this could not be managed appropriately as a class action and denied certification on grounds of superiority. With respect to the predominance of individual issues over common issues, the point, and your question, Your Honor, got to this, the point that the plaintiffs miss is that they must prove liability in addition to misclassification. Misclassification alone is not enough. In the Soleto case, the court wrote, appellant's allegation that respondents have misclassified putative class members as independent contractors rather than employees is only part of the equation. Appellants have not alleged that respondents have uniform policies or practices beyond the issue of employee misclassification that would establish liability for overtime or rest or meal break violations. In other words, they have to show liability as well. In the Jaime's class action was certified because the employer's policy of assigning the drivers to long delivery routes that required them to work overtime and did not allow them to take breaks was a uniform policy that violated labor law. In the Soleto case, class action was not certified because the employer's policies did not require or encourage violation of the labor law. In Duran, the Supreme Court wrote, although as a general rule, can you still hear me?
Yes.
Yes.
Okay. My screen has gone blank, but if you can still hear me, I will carry on. Okay. Well, I can't see you anymore. I cannot no longer see you. But anyway, in Duran, the Supreme Court wrote, although as a general rule, class certification will not be denied because class members must individually prove their damages, class treatment is not appropriate if every member of the alleged class would be required to litigate numerous and substantial questions determining his individual right to recover. And that's what we have here.
Counsel, you've got about 1 minute remaining on your time.
All right. Well, let me then just say that individualized proof is going to be necessary to show liability for each of the causes of action. And I'm going to make a concession with respect to only with respect to the wage statements cause of action. That is the only cause of action which would mere misclassification would automatically result in a violation. The plaintiff's meal period policy is you're completely free to do anything at any time. That satisfies their requirement. Because they are required to show liability, and it can only be done in this case, and I think we've discussed this in the brief, by individual testimony. The court's conclusion that there's ample evidence in the record to support the court's conclusion that individualized testimony is necessary to establish the wage and hour claims, also the reimbursement claims, also the failure to pay timely final pay claims. Denial of class certification should be affirmed on this ground and also on the ground that class action is not the superior method of adjudication. And if there are no questions, I will submit.
Okay. Let me ask, are there any questions? Justice Guerrero, Justice Irian?
None for me, thank you.
I just wanted to clarify what the concession was. Are you referring to the itemized wage statement?
Yes, and but I would point out that even that, nevertheless, the court did not dispute or abuse its discretion by denying certification as to the case as a whole, rather than saying, okay, we're going to certify on this one cause of action, and the rest of you go to trial.
Thank you.
Okay, thank you. Unless there are any other questions, Mr. Wheeler? You have about 5 minutes remaining.
Thank you very much, Your Honor. The concession that I just heard compels reversal under Gonzalez and under the standard of review. This court only reviews the stated reasons for correctness. There was no, as in Gonzalez, zero analysis of the individual cause of action breakdown. And if the trial court had undertaken that analysis, it would have certified the 226 itemized wage statement cause of action, because there is zero argument that any variability of anything applies to that specific cause of action. So if the prong B analysis, which is, and just I remind Your Honors that the Soleto case, the McCleary case, all the cases the defense discussed, they are pre-dynamics. It is apples and oranges. You cannot take a look at a S.G. Borello and Sons multifactorial test and compare it to the burden of proof on the employer's affirmative defense of proper classification, given that sea change in the law. So those cases are just completely inapplicable. But if the plaintiffs, let's just imagine that that was our only cause of action, wage statements. We compare the core job duties, because what I heard on the superiority argument from the respondents is that the variability is all over the map. But not, Your Honors, with respect to what these people did. As I mentioned earlier, yes, the times that they worked, where they gathered the signatures, what time they chose to do so, those are different. And maybe everybody does have a different story, but everybody has a different story in every employment class action that's ever been filed in the history of this state. The question is not, does everybody have a different story? The question is, do the common issues predominate, and is the class action device the method by which to decide everybody's cause of action? In a post-dynamics world where you have a singular question, is what these people do, the core job duties of these putative class members, can you take them? And by the way, they're undisputed. Again, what they do, how they do their work, how they achieve what they're paid to do does not differ. They pick up the forms, they go out into the field, and they get them signed, they take them back, and they get paid when they turn them into the defendant. That's it. Under prong B of dynamics, you apply those core job duties to the usual course of business test. And if the defense can't prove that prong B, they lose that question. There's no variability in that liability analysis. And that is the extent of the liability analysis on classification. So where do you go from there? And Your Honor, different labor code standards have different individual issues of proof. I recognize that. They're not all uniform. And that's why I highlight for Your Honors the problem with the trial court's order. Because if the trial court had done what Gonzalez compelled it to do and actually engage, as most trial courts do, in an analysis of every cause of action, it might have said on overtime or business expenses, just by example, not by concession, Your Honors, but it might have said, as to those claims, I don't think this can be certified. But there's no reasoning and no defensibility to denying the wage statement class action. And I believe the meal period, meal and rest are two different legal standards, but starting with meal periods, there's a different standard there. And when you look at the Bradley case, it completely refutes what the Respondents' Counsel just said. What Bradley tells us, cited repeatedly in our papers, Your Honors, is that if there is no meal period policy, and there's a request for admission admitted by the defense on this, no meal period policy, in that world, under Bradley, the fact that some people may have taken a meal and rest break does not compel the denial of class certification. That is the Bradley case. Because Brinker holds you must provide a meal and rest period, you actually must have a policy in place to provide it and allow the employee to take it. If you do not have such a policy, which in this case is admitted, there are violations. And then the question is, how many? And under that rubric, there are 166 putative class members. There will have to be some representative testimony on overtime and meal breaks as far as damages. But that's damages, not liability. Under Bradley, under Gonzalez, we see that the independent contractor liability question does not bear on damages questions. If they're misclassified, then you get into the damages, which is how much are they owed. And that's because, in this case, unlike most, zero labor code policies. So the question is, well, they gave them a policy to take breaks, or there's an overtime policy, and was it met? That's the question in many cases the defense referred to. Not here. Zero policies. So in the absence, the dearth of those policies, what does representative testimony look like? Well, there's a very manageable number of putative class members, something that the trial court also failed to consider, 166. What is a reasonable, and as we referred to by citing the Bell case and several other cases, Bell versus Farmers, Your Honors, in several other cases, you do have to take testimony from some number, and this is done after certification when you're proving up your damages element at trial. How many people do you need to hear from, and what's a representative sample? And there are some labor code violation issues where you must take that kind of testimony. That is done in nearly every class action. And that's why the case law in California is replete with references to the fact that you must take individual testimony on damages does not compel denial of certification. When the plaintiff's theory of recovery is misclassification, you decide that issue first, and damages issues are different. There's a relaxed burden of proof, especially in a case like this where there are no employment records. The case law in California, Hernandez, U.S. Supreme Court in Mount Clemens, does not allow a defendant to profit from the lack of records. That's why the much lowered evidentiary standard in a case like this is just and reasonable inference. The plaintiffs are allowed to prove their damages by just and reasonable inference in the face of a lack of employment records. Let me just, if I have any time left, Your Honors, I just want to see if there's anything else I needed to respond to. I don't think so. What I'd leave Your Honors with is the Gonzalez case and the reversal and the directions on remand instruct, I believe, what Your Honors ought to do in this case. Trial court completely failed to analyze the theory of recovery and did exactly what Gonzalez compels trial courts to not do, which is a wholesale denial of class certification without looking in detail at the causes of action. Thank you.
Okay, thank you, counsel. Unless there are any questions, do we have questions from the panel?
None.
No, thank you.
Syrian. Okay, very good.
Your Honor, may I indulge the court?
Well, actually, counsel, this is going to seem hard-hearted, but no. Otherwise, we will have another trail of discussion. You've covered it. We've got the briefs. We've got the arguments. So at this point, I am going to go ahead and submit the case.
I'm sorry. Please excuse my interruption, but I would like to. The point that I would like to make is in response to something in the reply brief, which is not before the court.
Counsel, I'm going to end the discussion at this point.
Okay.
Thank you. We're well of the response briefs, and we have read them, and you covered the area very well. So thank you. The case is submitted. We're in recess until this afternoon at 1. Thank you.
Thank you, Your Honor.
Good afternoon. I'm here.
Good afternoon, sir. Good afternoon, Justice Aaron.
Good afternoon, Michael.
I can see and hear you well. Thank you.
Thank you.
And Attorney Rachel Garrard.
Good afternoon, President.
Good afternoon. Thank you. Everyone, please remember, if you experience any technical difficulties during the session, please exit immediately and reconnect using the phone number and access code that I emailed you this morning. All right, please, you can turn your videos off and put yourself back on mute, and the court will join you shortly. Thank you very much. Everyone is present. Justice Howard.
And Michael, I think we're about 8 minutes before 1:30, correct?
Yes.
Okay. And I know our CHP officer, Jason, is not here. And who will be calling the court to order?
Excuse me, Officer Reynoso is with us.
Present, Your Honor.
Great. Well, we'll wait because I always hate to start before the public is advised that we're going live. So we'll hold tight till 1:30.
Thank you, Your Honor.
Thank you.
Michael?
Your Honor?
Just to verify, both Beltran and Shaker are off calendar?
That is correct.
Thank you.
You're welcome. Good afternoon, Justice Banky.
Hello. I'm not on first. I think I'm third, but I'll stand by.
That's correct, but I can hear you well. Thank you.
Okay, thanks. Can you see me? I don't see me.
I cannot see you, but I can hear you.
That's interesting. I wonder if it's that problem with the slide.
You're on mute if you're speaking, Justice Aaron.
Yeah, it's showing your background.
Yeah, it's just showing background.
Yeah.
I'll see if IT can reach out to you.
Okay. Still don't see me.
Contacted IT. They'll figure it out, Your Honor.
Okay, thanks.
Yes, we can see you now.
Uncovering your camera.
Happens to all of us.
Alex found it immediately.
Right. It is 1:29. So, Officer Reynoso, I'm going to ask, sir, if you would please call the court to order.
Yes, Your Honor. Good afternoon. The 4th District Court of Appeal, Division 1 is now in session with the Honorable Judith Holler presiding. We ask that you please mute your microphone and turn off your video camera until your case is called. The first case this afternoon will be Radcliffe and versus Interfaith Community Services. Thank you.
Right. Good afternoon, Ms. Radcliffe. I know you are appearing by telephone, and Ms. Kushner, we can see you on the video. I'm Justice Haller. I will be presiding, and joining me on the panel are Justices Aaron and Justices Guerrero. So with that, Ms. Radcliffe, we will hear from you first. You've indicated that you would like 15 minutes. Do you want to save some of that time to reply after you hear what Respondents' Counsel has to say? Ms. Radcliffe, can you hear us? Michael, do you want to see if you can get Ms. Radcliffe back by telephone?
Yes, Your Honor. We may have lost her all of a sudden. I'll check on that real quick.
Okay, thank you. We'll hold tight.
Is this mean I can speak or not speak? He can speak.
Right.
She's back, Your Honor.
Okay, good.
Hello?
Yes, Ms. Radcliffe, this is Justice Haller. I will be presiding today, and I am joined by Justices Aaron and Guerrero. And counsel for the respondent, Ms. Kushner, is on video. You have indicated you'd like 15 minutes for your argument. Would you like to save some of that time so that you have time to respond to anything that Ms. Kushner may say? All right. How much of the 15 minutes would you like to reserve?
No, I think I'd like to reserve like 5 minutes, maybe.
That will be just fine. That will be fine. I will do that. All right. Ms. Kushner and Ms. Radcliffe, we have read your briefs. The file has been thoroughly reviewed. We are familiar with the facts of the case and the issues. So, Ms. Radcliffe, if you would like to begin to tell us why you believe the court erred in granting the summary judgment.
All right. Thank you, Your Honors. I'd like to state at the outset that due to my medical condition and the medication that I'm prescribed, my recall may be delayed, but it's always accurate. So I'm asking for is to bear with me.
We are happy to do that.
Thank you so much. May it please the court. My name is Victoria Radcliffe. I am here today as a petitioner in pro per. I respectfully ask this court to reverse the Superior Court's decision for summary adjudication of issue 4, referencing constructive eviction, issue 5, referencing defective conditions affected the premises habitability, issue 6, referencing the triable issues of fact of Respondent Interfaith Community Services, Inc. They are the ones that violated the lease. And I also want to include the additional statute of undue influence under California Civil Code 1575 and Institutional Code 15600 through 15675. because the reason for this is because the dependent element was not enacted until 2019. Your Honors, this case is about elderly, disabled renters having the same rights afforded to them as any other renter. The majority of seniors are law-abiding and want to live peacefully on their rental property, whatever it may be, and not have the property manager or landlord enter their unit unlawfully to harass and intimidate the renter, causing mental suffering and intentional infliction of emotional distress. I am not afraid to say what Interfaith did to me is a crime, and they should be punished for pain and suffering they caused. First, Respondents' Counsel wants to convolute and incorrectly account the triable facts in issue in this case, as exemplified by his brief. And I want to be clear as to the initial cause of my suffering, along with the breach of contract, was when Tracy Chester, the property manager, entered my unit within 9 days of me moving in. When she did that, she violated the terms and conditions of the lease, which I just signed, and which is also documented throughout the court filings. At the time, I had never met Tracy Chester. At that point, when she entered my unit, I could have called the police. It would have been a criminal trespass. But, and I also want to note, she didn't give any notice that she was coming. Secondly, there is conflicting evidence brought by Respondent Counsel's brief that provided to the court of the date I vacated the unit. The police report states September 8th, 2015, of when I left the unit, moved from the unit. And that was because I got the police to escort me on the property after living the weekend in my car in a vacant parking lot. I called the police, they came out, I went to the unit, collected my belongings, and left forever, never to return on September 8th. I picked up the police report on the 9th, which is a mistake the Respondent Counsel made in their brief. They said that I left on September 9th. No, I picked up the police report on September 9th. The 3 and 30-day notices that were given to me on September 18th, 2015, in Respondent Matthew Brown's office at Interfaith. By that point, I had moved from my unit and was living in my car. Your Honors, let me be clear that I left the unit definitely on September 8th, 2015, to move out as provided by the police report dated the next day, because they accompanied me back to the unit. Thirdly, Interfaith failed to provide me security measures or duty of care under the lease if another tenant was conducting drug dealing activities or causing a nuisance on their property. As a nuisance through the enactment of Section 11570 of the California Health and Safety Code, I should not have been put in jeopardy because I came to the respondent Interfaith Services for help. That was very disappointing and hurtful. Along with the restraining order filed by Respondent Sandra Stowe, the evidential acknowledgement by the respondents, Angela, Rios, and Brown, in an email dated August 24th, 2015, the same day the respondent, Tracy Stowe, my roommate, filed a restraining order against me. In the email, it states, Sandra, this is Brown to Rios and Angela. It says, Sandra reported to me in confidence that she is filing a restraining order today against Victoria. She asked me not to tell Victoria, and I assured her that I will not. This is located in Volume 3 of the court transcript on page 586. Her filing a restraining order against me put me at risk of access to my food, clothing, and shelter. This shows these respondents having prior knowledge and secrecy about the unlawful restraining order, so that they knew that I would suffer for lack of food, clothing, and shelter, and would place me at a hardship. And these are my roommate, Sandra Stowe, also filed additional restraining orders against every roommate she's had for the past 2 years. And the case numbers for the restraining order is 36-2015-000-60972-CUPTNC and 36-2017-0003602 PTNC, and this is in Volume 3 of the court record, pages 626 and 627. Within approximately a 20 to 24 month time frame, she filed these restraining orders against her roommate. So what I'm asking here is, at what point does the court find the unit to be uninhabitable? Is it because of undue influence? Undue influence is defined in Section 1575 of the California Civil Code as the use of one in whom a confidence is reposed by another, or one who holds real or apparent authority over him, or in the taking an unfair advantage of another's weakness of mind, or taking grossly oppressive and unfair advantage of another's necessities or distress. This court must consider 4 factors in determining whether undue influence has been exercised, including the vulnerability of the victim, the influencer's apparent authority, the actions or tactics used by the influencer, and the equity of the result.
Ms. Radcliffe.
And the elder abuse dependent.
Ms. Radcliffe, excuse me for interrupting you. It's Justice Howard. You'll recall that when you filed this lawsuit, there was an action brought by the respondents called a demur, and the court said that none of your what are called tort causes of action could in fact go forward because your complaint was not filed in a timely fashion, but the court did allow the constructive eviction, the uninhabitability, and the breach of contract to go forward. Those are the 3 claims that are before us on the summary judgment. And while I appreciate your referencing undue influence, that was not something encompassed within the summary judgment or is before us today.
Oh, and it can't be included, is what you're saying?
That's correct.
At this point. Okay.
And I also wanted to let you know, you have gone beyond the 10 minutes you wanted. Were there
Right.
a few other things you'd like to say, because we certainly want to hear them, and I want to make sure you have some time for reply.
Go ahead with the reply.
Oh, okay. All right. Then for right now, then we'll go to the respondents. Ms. Kushner, it's your opportunity to address the court.
Good afternoon, Your Honors. May it please the court. Rachel Kushner on behalf of the respondents. This court should affirm the trial court's order granting summary judgment for the respondents. Plaintiffs failed at the lower court to bring any admissible evidence to raise a triable issue of material fact with reference to any of the three causes of action at issue: the constructive eviction claim, breach of warranty of habitability, or breach of contract claim. The appellant argues that there was an unlawful entrance into the unit, and that is the basis of the breach of contract claim. The evidence before the trial court was that when respondents went to enter the unit, they first knocked, and that a neighbor that was in appellant's unit said to come on in. Appellant testified that she heard some communication between the neighbor and the respondents. She couldn't recall what it was, but respondents under oath submitted a declaration that they were told they could come in. They came in the unit, they greeted appellant. Ms. Radcliffe didn't tell them to leave. There was consent. The breach of contract claim also fails because appellant wasn't in compliance with the lease at the time. She was not permitted to allow her daughter to move into the shared unit, and she did. This was raised in, she testified to that, and respondent's declaration show that. There is no triable issue of material fact that she raised or created to proceed with the breach of contract claim. The date of that she vacated the property, this goes to the constructive eviction claim. Of course, constructive eviction requires an abandonment of the premises shortly after or within a reasonable time of the wrongful conduct. Whether appellant left the apartment on September 8th is not what's at issue. It's when she gave up possession of the premises. Ms. Radcliffe testified that on September 8th, she still lived in the unit. She submitted an email on September 8th to the respondent saying, "I am still living in the unit," even though she had left for the night. The case law is clear. She must have abandoned possession of the premises, and that wasn't done until the notice of eviction was issued September 14th, 2015. Ms. Radcliffe brought no admissible evidence to the trial court to raise a triable issue of fact as to these claims. Lastly, the breach of warranty of habitability claim fails because all of the evidence before the court showed the unit was in good condition. It wasn't in defective condition. Ms. Radcliffe and her daughter testified. The unit was in good condition. It had water, it had electricity, there was no bug infestation. Everything about the unit itself was in good condition. There was no evidence presented to raise triable issues of fact for any of these causes of action against any of the respondents. And for those reasons, Your Honor, this court should affirm the lower court's granting of summary judgment. I'm happy to address any questions Your Honors may have.
Right. There appear to be none. Then, Ms. Radcliffe, you have 5 minutes to respond.
Okay, it was so much that she stated as fact that is total hyperbole. It makes absolutely no sense. There is absolutely no way would I stay in an apartment past the time the police escorted me off the property. Okay? So you saying that I would stay there after being used and abused does not make any sense. That's all I'm going to say. You know, I may not know law, chapter, and verse, or whatever you want to call it, but I know that they damaged me, and they hurt me, and they should pay for that. And I am not going to stop. I may not have said the right wording or the right words so that your honors will understand what I'm saying, but somebody will understand, because I'm not letting it go. All right? So do what you will. Thank you, your honors.
All right. You still have some time. Is there anything else you wanted to bring to our attention?
No, not at this time.
All right. Ms. Radcliffe, let me explain the process from this point forward. We are obligated to make a decision. We're going to do what's called submit the case today. That means that within 90 days of today, we have to provide you and the other side with a decision that is written that sets forth our reasoning for our conclusion. We will do that within 90 days, if not before, and that will be served upon you and Ms. Kushner. So the matter is submitted, and you will have a written opinion no later than 90 days from today.
Okay. Thank you very much.
Thank you very much.
Thank
The
you.
matter is submitted. And the next item on the calendar will be People versus Green, and there will be a panel change.
Thank you very much, Justice Haller. The panel now is myself, Presiding Justice McConnell, Justice Aaron, and Justice Guerrero, and we'll hear the matter of People versus Green. Ms. Mazur, how much time did you wish to reserve to respond?
I'd like to reserve about 3 minutes, Your Honor.
Thank you. You may proceed.
Okay. May it please the court, I'm Janice Mazur, appearing for the appellant, Timothy Green. The trial court has, of course, broad discretion in setting a restitution amount, particularly when restitution is awarded as a condition of probation. However, that discretion is not unlimited, and the court is required to use a rational method to determine the amount which will make the victim whole, and it may not make an order which is arbitrary and capricious. As the court stated in People versus Goulart, a condition of probation may be deemed fundamentally unfair if the judge improperly considers unreliable information, and due process demands that the penal system be concerned with the probable accuracy of the information that's being input into the process. And it's not only fundamentally unfair for a court to consider false information, but it's also unfair for it to consider evidence that's vague or inaccurate. In addition, where a victim has made a prima facie showing on a restitution claim, the defendant has a right to present evidence to rebut that claim. In this case, I believe that the record overwhelmingly supports a finding that the evidence which the court relied upon, which resulted in a restitution award of over $3.6 million, was unreliable, vague, inaccurate, and most likely false. And further, I think the court's refusal to order the victim to produce its tax returns for the years for which it claimed those business losses.
Excuse me, Ms. Mazur, this is Presiding Justice McConnell. The court did order a great deal of discovery aside from the tax returns. And it's my understanding that with the profit and loss statements, defense counsel thought there was enough information to go forward.
Well, actually, at the hearing on the motion to quash the subpoena for more financial records, counsel indicated that he wanted to have both the profit and loss statements and the tax returns. At one point, he said...
Excuse me, Ms. Mazur, but he said the tax returns don't really help me.
But then he went on to say, let me be clear, I want to see the whole picture. I'd like to see the tax returns. That's
right,
important
okay, so he
too.
wanted to see them, but there is a statutory privilege. And which exception to the privilege would you say applied to that the court did not recognize? That
Well,
would
Your Honor,
required production.
I think that in terms of the tax returns, because this was a business entity rather than a person, there is a right to privacy, but not a privilege. And the
statutory privilege. There may not be a constitutional privilege, but there is a statutory one, isn't there?
Right, and I think that required the court to engage in a weighing process to weigh the importance of the information versus the right to privacy, any right to privacy that might exist at that point as far as the tax returns go. Because this was a business entity, and in addition, on another layer on top of that, most of the clients of the business entity were also business entities. It sort of, I believe it reduces any concerns there might be in terms of privacy. And when you weigh that against the overwhelming importance of getting accurate numbers, particularly, Your Honor, when we have a situation that we have here, very unusual, that the probation report said that the restitution amount that was being sought was $1.4 million.
Well, it said that, but it also indicated that, I don't know how to pronounce her name, Nicole.
Laser, like laser.
The actual losses were probably 3 times that amount.
Well, the amount that they originally relied on, the defendant relied on, was the $1.4 million. That pretty much doubled by the time they got to the hearing to something over $3 million. And then from the morning to the afternoon, that day of the restitution hearing, it doubled again to over $6 million. So that, I think these facts by themselves would suggest that the estimates in terms of what the actual loss was wildly inaccurate. And
Counsel, this is Justice Guerrero. Just wanted to clarify that the standard, I think the difficulty you have is the standard, and to the extent that there are conflicts, weren't those resolved against your client? And we looked to see if there was sufficient evidence, and in this situation, it appeared that there were 2 different methods primarily that were used. And what I'm, I guess, stuck on is that there were credibility determinations against your client, and what are we supposed to do with that?
Well, as far as thank you, Your Honor, as far as the credibility determinations against my client, the court found that because he was a convicted felon, because he had pled guilty to one of the 2 charges, that the court didn't have to believe him. But I think that on the facts presented, even if you completely disregard my client's testimony and ignore it like it never happened, still the testimony that was provided by the company was wholly vague, unreliable, and probably false. I think that when we have a situation where the manager of the company, who by all accounts is basically running the company on her own, she had no idea, and this was her testimony, no idea what the actual profit of the company was in 2012. She said she hadn't paid any attention to what their own profit and loss statements were, even though they'd been prepared by their tax accountants. We know that the company suffered a loss in 2013, which is the year that the 2 defendants were hired as independent contractors. And in 2014, the company made a very, very small profit of only $15,000. So if we take this, no information about 2012, a loss in 2013, $15,000 in profit for the whole year in 2014, how in the world can we come up with any kind of reliable information that the company somehow suffered $50,000 a month, every single month, from 2013 through 2018, that's attributable to these defendants? On its face, I think that's just, it doesn't make any sense, apart from the fact that on her own records, Exhibit 1 and Exhibit 2, one was twice as much as the other. The
methods were different.
The methods were different, but you think that even using different methods, they have some kind of vague connection to one another. But I think probably the most important bit of evidence here, too, is that even the district attorney admitted that all of the evidence submitted by All Roads Communication reflected gross figures, not net figures. So it wasn't showing profit and losses. It was showing revenue and billing. Well, the fact that they bill X dollars doesn't mean that they've lost X dollars if those clients go away. And I think one of the key facts that helps to establish that is the fact that they had been sued by their airtime supplier, which is basically the service that they're providing, for over $700,000 over the course of these same 2 years that we're talking about.
This is Justice McConnell. Could you take me back to the standard of review here? I mean, you're arguing as though you were before the trial court, and we're not the trial court making the determination. Could you tell us what you think the standard of review is and why, based on that, we should reverse?
Well, it's an abuse of discretion standard, I think, and I think that in this case there was insufficient evidence. I guess would be more accurate to say, but I don't think there was sufficient evidence to support anything close to $3.6 million because only gross figures were submitted, and that doesn't show what a loss is. The point of restitution is to make the victim whole. And so, if I have a business
were stolen, if the customers were stolen and the amount of revenues from those customers were the gross amount, why isn't that the loss? I mean, the company still had to pay its overhead. Why should their losses be limited to their net?
The company wasn't paying overhead for those people through 2018. She extrapolated what she deemed were losses from 2013 and said, well, geez, for some of these clients, not all, but for some, we continued to pay their airtime, right? But certainly that didn't happen all the way to 2018. They were well aware of whatever these lost customers were. So to suggest that a company that was losing money and was not making any profit in the years preceding and during the years where these people were working for them, that 5 years into the future, every single penny that they claimed they might have made in 2013 and didn't make in the next 5 years was attributable to the acts of these defendants seems wholly unlikely. And particularly when they're gross figures, so when going back for a moment, Your Honor, to the Immerstat lawsuit, if they owed $700,000 over the course of 2 years to their airtime supplier, and I've done the math in the reply brief, so I won't go through it, but it comes out on average that their fees that they were supposed to be paying to the airtime provider were over $26,000 a month. So you've got to take that out. If you're looking at gross revenues, you've got to deduct those kinds of expenses in order to get to what your net profits were. Even the trial court seemed to acknowledge that she should be awarding based on a net loss, not a gross loss. And she said, why would I award gross amounts? And the DA said, well, I really don't know what they're doing.
For one reason, there's case law to the effect that in a commercial context, lost gross is a correct measure for restitution.
I am unaware of that case law, Your Honor. I haven't seen that in the briefing from the respondent, that gross loss is the accurate measure. They argued that this was close enough. It was a guesstimate as to what the net loss would have been. So I think the people appear to agree that it should be based on net loss, and they're arguing that this $3.6 million was close enough. And I would suggest that there was no reliability in these figures. And I think having the tax returns would have at least provided the defendant with an opportunity to compare the figures that Ms. Garagnani was producing, and since they were so different from what was produced in the profit and loss statement. If she's claiming, well, we lost $50,000 a month, and the profit and loss showing they didn't make anything near that, the tax returns at least would have provided some ability to corroborate.
Well, what she's saying is that as a result of the stolen customers, they lost that much revenue. But if those customers had stayed with them, they would have been billing them whatever amount they had been billing them before.
But when they had those customers, they didn't make that much money. even before these two defendants came on board this. And also, in addition, casting further doubt on the credibility, we have to remember that this company also had made the exact same claims 2 years earlier against several other former employees. So this is the most unlucky.
In that case, all of the customers went back to ARS. Isn't that a significant difference?
So says Ms. Garagnani.
You're asking us to make credibility determinations?
No, I'm not. I'm asking the court to look at the evidence that was presented and see that it was insufficient to support a finding that there was an actual loss or anything close to an actual loss of $3.6 million. And I think I understand that this argument is as to the appeal and not the habeas corpus, but I think the court has inquired whether they should take judicial notice of the evidence in support of the habeas. And I think that evidence casts further doubt on the credibility of the sole witness for the business.
All right, Ms. Mazur, you've used up most of your time. Did you want to save a minute or two to respond?
Yes, thank you, Your Honor.
All right, thank you. We'll hear from the Deputy Attorney General.
May it please the court, Deputy Attorney General Amanda Lloyd on behalf of the people. As has been discussed, restitution in the criminal context is not the same as damages in the civil context. The purpose of restitution is to make the victim whole. And in the case of restitution as part of a probation condition, the trial court's discretion is even more broad than in the case of restitution with a prison commitment. As this court found in People v. Millard, a prima facie case for restitution is made by the people based on the victim's testimony or other claim or statement of the amount of loss. And that is what we have here. The prosecution presented a prima facie case of loss based on Ms. Garagnani's testimony and statement about the losses that Allroads sustained. We compiled spreadsheets showing the losses, as the court noted, two different ways to calculate the losses. First, based on merchant sales statements and the differences over the years of the losses. And the second way, based only on the 85 clients they could identify that were stolen, which cut the losses almost in half. And that's the number that the trial court found was supported by the evidence presented by Ms. Garagnani. The trial court did not abuse its discretion by relying on that information. It was appellant's burden after the prima facie case was made to rebut the victim's case. He did testify at the hearing, and the court found, quote, the court does not find Mr. Green's testimony to be credible. He is also impeached with this conviction in this matter. So in addition to the conviction, the court simply found him not credible, his testimony not credible, and the amount of restitution he was offering as not credible. Appellant spends a lot of time discussing the evidence that was before the trial court, but as this court noted, here we're on an abuse of discretion standard. This court does not reweigh the evidence or reweigh the credibility determinations made by the trial court who heard the evidence firsthand. Also of note, the profit and loss statements that counsel discusses were not submitted as exhibits during the restitution hearing, whereas the documents submitted by Ms. Garagnani were exhibits the court was able to review and base its decision on. With regard to the tax records, I think the court covered that issue well, both the defense counsel's statements that the tax records really weren't necessary and he really just wanted the information about the company's profits, and also the privacy interests in the tax records support that there was no abuse of discretion in denying simply the tax records and permitting all of the other discovery requested. And as to the amount of restitution, there is no requirement that the restitution order be limited to the exact amount of the loss in which the defendant is actually found culpable, and that's People v. Carbajal. Here, Ms. Garagnani testified that she couldn't even determine the exact amount because appellant and his co-defendant had deleted much of the information from their files and changed much of the information such that they couldn't exactly reproduce the numbers. They did the best that they could with the spreadsheets they had and the business records that they could put together to determine their losses, and it was a reasonable basis for the trial court to rely on that amount presented. Unless the court has any questions, I'd be prepared to submit.
Are there any further questions, Justice Aaron or Justice Guerrero?
No, thank you.
No, thank you.
All right, thank you. Ms. Mazur, you may take a minute or two to close.
Okay. Well, thank you, Your Honor. I would agree with counsel that the purpose of the restitution statute is to make the victim whole, and it's not to give them a windfall. And in this matter, we have no evidence that this company was ever profitable. It was making zero money before these people came into the company, and then suddenly, I think presented evidence that was not corroborated that they were losing $50,000 a month based on what they were billing, not what they were earning. And so if they were billing $50,000 a month and making a profit of $1,000 a month, they should be for sure reimbursed and get restitution for the $1,000 a month. But they made no showing whatsoever as to what amount they actually lost as a result of the conduct of the defendants. The fact that the manager admitted that she ignored her profit and loss indicates that which was based on what their actual dollars were, shows that the evidence was inadequate. I don't suggest that the court had to come up with an exact amount. It has to come up with something that is within the realm of reasonable, not arbitrary and capricious, and it can't be based on vague or inaccurate numbers. And in this case, I think that the district attorney's statement that when the judge asked him, why should I grant the gross amount as opposed to the net amount, and he said, all of the exhibits are gross. I don't have an answer for what the net amount is. And the closest I can get, probably maybe the most accurate one is the center number in the three numbers, 1.4 million, 3.6 million, and 6 point something million. That's a pretty wide range of numbers. So to just kind of pick one out of the air in the middle when there isn't any verification of the amounts, I think constitutes vague and inaccurate evidence.
All right. Are there any further questions, Justice Aaron or Justice Guerrero?
No questions.
No, thank you.
Okay, great. Thank you very much. The matter is submitted. We now have another panel change, and we'll be joined by Justice Benke. Thank you, Justice Aaron. I think you're finished. So now the panel is Justice Benke, myself, and Justice Guerrero, and we'll hear the matter of Agrobiosol versus Agricola, EPSA. Mr. Ayers, you're the appellant. Would you like to reserve time to respond?
Yes, Your Honor. I'd like to reserve 5 minutes, please.
All right, you may proceed. Please state
Thank you, Your Honor. May it please the court, Ray Ayers for appellant Agricola EPSA. This appeal largely involves two issues. Primarily one of whether the penalty interest awarded by the court was actually final and enforceable such that the court should have awarded that amount. And secondly, whether the court should have granted the appellant's motion to withdraw the stipulation as to the finality of the underlying judgment once there was a collateral attack appeal filed on the underlying judgment in Mexico, which then rendered it not final and enforceable in Mexico. Excuse me. The court in Mexico entered judgment on a promissory note of approximately $500,000 in favor of Agribiosol and against EPSA. Agribiosol filed a motion or a complaint here in order to domesticate the judgment. The parties agreed to stipulate that
the history of the case.
Yes, Your Honor, I'll move along. The issue here, Your Honor, is whether or not the court entered in its order applying the interest calculations from the judgment. As we've submitted in the papers, there's no offer of Mexican law from Agribiosol as to whether those amounts of penalty interest, which is not the standard judgment interest, are final and enforceable. And pursuant to the Uniform Foreign Country Money Judgments Act, under CCP 715A and C, Agribiosol bore the burden of proof of demonstrating that the judgment not only grants a sum of money or that can be calculated, but also that it's final, conclusive, and enforceable. And as the extensive declarations of Mexican counsel with supporting Mexican case law and statutory law demonstrate, and even the face of the Mexican judgment shows, the Mexican judgment is not final as to the penalty interest of some 60% per year until unless the ancillary proceeding, which the judgment itself mentions, takes place in Mexico. And here the evidence is that there's no such procedure that's taken place, that the chance to oppose the ancillary procedure has not been taken, and there's no subsequent order of the Mexican court that it's enforceable. And in fact, Agribiasol makes no real effort to argue that the exorbitant amounts of interest that it seeks are actually enforceable under Mexican law. It tends to skirt the issue. It offered no real declarations of counsel, and instead argues that the parties agreed to this amount of interest, which is the exact opposite of what they did. They agreed that the judgment could be enforceable as to the principal, but not as to interest and fees, because the parties disagreed on that. And the court seemed to take the position, the trial court took the position, it appeared, that once you're going to recognize it for part, you might as well recognize it for all. But that's incorrect, because a judgment can certainly be enforceable for part of the judgment and not for other parts. And we cited to several sections of the restatement on the conflict of laws, particularly sections 101 and 107, which says that 101 comment B says a foreign judgment for the payment of money will not be enforced in an amount greater than the amount, including costs, for which the judgment is enforceable in the state where it was rendered. And clearly the law of Mexico applies here. That's expressly stated in the statute. And so there's no question about whether they need to demonstrate what Mexican law says. And so if you look at comment D of section 107, it says a judgment may be final under the local law of the state of rendition as to some matters and not yet final as to other matters. Here you had a judgment that the parties agreed was final as to the principal amount, but not as to penalty interest.
Mr. Ayers, this is Justice McConnell.
Yes, Your Honor.
The stipulation referred to recognition of the judgment as a whole, not to any particular part of the judgment. It referred to the judgment as a whole.
Your Honor, the stipulation said that the California judgment is to be entered as to the principal amount plus attorney's fees and costs, if any, in amount determined by the court. And it said the interest rate to apply prior to recognition is to be determined by notice motion. So the parties didn't stipulate that this judgment interest was final. And in fact, there would have been no purpose for the motion if they had. If they had actually stipulated, then there would have been no opposition. The parties would have simply stipulated for entry of the judgment in whole.
Well, so, the interest kept running, didn't it?
No, the parties had previously reached an agreement that the interest would stop and be entered non-pro-tunc as of August 1, 2018.
Okay.
And from this point forward, it would be the California judgment interest rate.
The 10%. Okay. Thank you.
And my position is simply that if there's nothing in the stipulation that says the parties agree that the judgment is final as to any amounts for interest, and they're making an argument that we stipulated that it was final, but not the interest rate. And that sort of begs the question, because if you don't stipulate to what the interest is, you still have a dispute about the finality and the amount of interest. And our position is, Your Honors, that if there's any interest that was awardable and final, it would have been the standard judgment interest. And the court's analysis in the Hyundai case that it relied upon and that Agribiasol urged deal with the conflict of laws issue. It's simply which jurisdiction's statutory interest rate applies, California or the foreign jurisdiction. And the answer is the foreign jurisdiction. The court looked here and said, well, this has this penalty interest. I think it's 5% per month. And in fact, Mexico's judgment interest is 6% per annum. And so you only get these additional penalty amounts pursuant to contract if you have the procedures that we talked about, so it's not automatically enforceable. So the court was looking at a step down the road, as it were, as opposed to the finality and conclusiveness of the interest award as to whether it's Mexican or U.S. or California interest. But we agree it's Mexican interest. and that interest is either none or it's the statutory amount because the penalty interest was subject to a subsequent procedure. And counsel for aggravated assault said it's akin to a memo of costs that this court could do it. And the court appeared to take aggravated assault up on that offer and said, I don't find that there is a substantive proceeding. There's no further issue, doesn't find that the judgment at issue requires further proceedings to determine the rate. There's no mention of a hearing on the merits. And the issue of a hearing on the merits is not the proper question. The question is whether the Mexican court has to do anything further, and whether it's a substantive or a procedural issue is irrelevant until those additional monies are incorporated into the judgment pursuant to Mexican law. They're not enforceable, and the California court can't take that laboring oar to do that. And Your Honors, on this point, aggravated assault submitted no evidence whatsoever. And on the, I'll briefly address the motion to withdraw the stipulation, Your Honor. As we noted, there was an amparo proceeding filed in Mexico after the initial motion on the interest and judgment enforcement. That amparo was accompanied by a court order that stayed enforcement of the Mexican judgment. Once that court order was issued, the circumstances changed, and we requested that the court allow withdrawal of the stipulation such that you would not have the anomaly of a judgment that's enforceable in California that's been stayed in Mexico. And our position was simply that the court should stay or allow withdrawal and not allow enforcement in California until those Mexican proceedings have been concluded or the stay lifted, Your Honor.
Counsel, this is Justice Guerrero. On the amparo proceedings, the court seemed to suggest that this was a strategic maneuver. Maybe maneuver is too harsh a word, but that it wasn't really a change in circumstances, but one that was created by the later filing of the amparo proceeding. Can you speak to why that wasn't done earlier?
I am not a Mexican attorney, Your Honor. I do not know why that was done earlier. I can only presume that they were not aware of that potential avenue to contest the judgment.
Well, is there any evidence in the record that this procedure was not known?
Your Honor, I believe there was a declaration from Mexican counsel that indicated that they had obtained new counsel and that they had looked at the issue, looked at the case file, and determined that there was this procedure. And when the trial court asked about this issue, the answer there is not that there's even if whether it was known or not known, but not whether there was a change in strategy or tactics by the appellant, but whether the circumstances changed. So nothing that the appellant did, unless it was in conformity with Mexican law and blessed by a Mexican court, would matter. So it wasn't the filing of the amparo that changed the circumstances. It's not a lesson until the Mexican court says there's some basis there for the proceeding and then issues the order that grants the stay that you have a changed circumstance. So even if there is a change in litigation tactics, we think that the trial court erred by saying the circumstance was simply that you changed your legal position or your posture. You say, no, it's actually a court order in Mexico that changed. And without that, nothing that the appellant did could change the finality of the judgment.
But my understanding is this is not something that would have happened on its own without seeking this additional remedy.
That's correct, Your Honor.
Thank you.
All right. We'll now turn to the respondent. Ms. Gerard, could you state your appearance, please?
Thank you, Your Honor. Good afternoon, and may it please the court. Rachel Gerard, appearing on behalf of Respondent Agrobiosol. I'd like to begin with the first argument raised by counsel that the trial court erred in domesticating the interest portion of the Mexico judgment. EPSA claims the trial court erred by domesticating that portion because the award was supposedly not a sum certain and therefore not final and enforceable in Mexico. A sum certain is defined as an amount that can be ascertained and calculated with precision and without reference to outside sources. Here, the Mexico judgment specified a principal amount, an interest rate, a start date, and an end date.
It thus includes everything needed to calculate the final award and is necessarily a sum certain as a matter of law. EPSA also claims that this portion of the judgment was not enforceable because it was not finally enforceable in Mexico due to the supposed requirement for an ancillary proceeding. However, Mexico law does not require an additional hearing in this case. According to even the declaration submitted by Mexico Council in support of EPSA's position, supposedly pursuant to Commercial Code 1330 of Mexico, a judgment that is an award for a set amount is, quote, enforceable immediately. Because we've already established that this is a sum certain, the amount was enforceable immediately in Mexico. The judgment was final in Mexico at the time it was entered. It was final at the time of stipulation, and it is final now and should be enforced. EPSA cited to the restatement for its claim that only part of the judgment was final and enforceable at that time. But that section of the restatement and the case law that's related pertains to judgments deciding liability only, such that the judgment could not possibly be final as to an amount of damages. Unlike the judgment in this case, which included not only a finding of liability, but also the damages and the interest to be awarded. Moving then to the next issue addressed by counsel, EPSA claims that the trial court erred in refusing to allow its withdrawal from the stipulation in light of the later filed amparo proceeding. However, stipulations are generally favored and treated as binding, even if contrary to some provable fact. And here, EPSA failed to establish any mistake, inadvertence, surprise, or excusable neglect. And that is the standard that needed to be fulfilled. As Justice Guerrero correctly pointed out, the trial court found that this was more of a manipulation of strategy than a genuine change in circumstances. And EPSA could not prove any supposed error was one that could not have been avoided by the exercise of ordinary care. Indeed, the amparo proceeding is something that the EPSA party took advantage of earlier in the case at a different time in this litigation. So even the counsel that missed the opportunity to file the amparo knew and understood that the amparo was available in certain circumstances. If the judgment was subject to collateral attack, then ordinary care required EPSA to ascertain and pursue that avenue before the stipulation was signed. Moving finally then to EPSA's argument that the trial court erred in failing to reduce the 5% interest amount. EPSA essentially claims the trial court failed to recognize its own discretion to reduce the amount as against public policy. However, the record is replete with references to this public policy argument. It was briefed extensively by the parties. It was raised to oral argument, and it was alluded to in the trial court's order, where the trial court says that it has the power to decide this issue, and then cites to and quotes from Hyundai, which also addresses the issue of policy. The record thus reflects that the trial court did not abuse its discretion as claimed. It's also worth noting that EPSA does not contend that the trial court erred in failing to reduce the amount, but actually that it erred in not understanding it could. Because the record establishes that it did, this issue must also fail. If the court has any questions, I would be happy to address them at this time. If not, then I will just briefly...
Do you have any questions?
No. Thank you.
Justice Guerrero, do you have any questions?
No, thank you.
All right, thank you. There appear to be no questions.
Okay, then I will just briefly conclude to say that in sum, the Mexico judgment was final. The trial court understood its discretion over the interest rate and did not abuse its discretion in denying EPSA's motion to withdraw, where it took volitional action to undermine the parties' agreement. Therefore, the judgment in favor of Agrobio-Sol should be affirmed.
Ms. Farrar, just so you know, in future court appearances, your bandwidth is low, and so your spoken word is not syncing with the movement of your lips. So that's something you ought to consider the next time you appear for oral argument. Okay?
Thank you, Your Honor. That's very hard to follow. I appreciate it.
Okay, thank you. Mr. Ayers, you may close.
Thank you, Your Honor. Counsel indicated that the Mexican law indicates that the judgment does not require additional procedure. We would respectfully submit that there is nothing in the record that demonstrates that. Under 715, aggregate assault bore the burden of proving that, demonstrating that the judgment was final, conclusive, and enforceable as to all aspects of the judgment. The party's stipulation was that the judgment may be recognized and entered as to the principal amount of the judgment. The parties disagree as to the applicable interest rate on the foreign judgment prior to recognition and entry, and whether attorney's fees and costs may be incurred. So there was no agreement on those issues. Otherwise, there would have been no need for the motion. And so therefore, they bore the burden of providing the court with some authority evidence to the effect that it was final in Mexico. They did not. And in fact, the judgment at page 34 of the record indicates on its face that the amount of interest shall be quantified for its liquidation during the enforcement of the judgment by way of ancillary procedure, because the amount is not claimed as a liquidated amount. And as the Mexican law and declarations we presented show, under Mexican law, that's not a liquidated amount. That means they have to come back to have the trial court go through this procedure, which is not a rubber stamp. The opposing side has an opportunity to oppose. And so because that special amount of interest is not available and not final, the most that Agrabia Sol would be entitled to would be the standard 6% per annum statutory interest, and no more than that, which was the crux of what the parties were leaving to be decided. EFSA submits that the trial court erred in applying the penalty interest, which was not finalized, rather than either awarding no interest because Agrabia Sol did not seek the 6% per annum, or awarding 6% per annum, which is the most that could be permitted pursuant to the Commercial Code of Mexico, which is the applicable law here. If there are any questions, I'm happy to answer.
Justice Benke, do you have any questions?
No, I do not. Thank you.
Justice Guerrero?
I do not. Thank you.
All right. Thank you very much. The matter is submitted. I believe that completes the afternoon calendar. Court is in recess. Thank you.